What you know, alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Sunday, January 26th. I hope you guys have had a great weekend. We're going to wrap up day 2 in the Bryan Kohberger hearing that took place on Friday. A couple of things here that I've had some listeners bring up. Some couldn't remember what led to this DNA evidence. Well, on December 27th, police took trash from Bryan's parents' house, which was in Pennsylvania. And the testing of that trash showed the DNA that was taken from the residence contained the DNA of the father of the person whose DNA was left on that knife sheath at the crime scene. And that's how that connection was made to Bryan Kohberger. The FBI submitted that as a tip to investigators and told them that they needed to build their probable cause around that DNA. That's how the trash pickup plays into this. It's been a little while since these murders happened, and it's easy to forget these little details as we move along. The other thing people have asked, wasn't this argued before about leaving the DNA evidence out? And the answer is yes. But why are they doing this again? Well, we had a change of venue. The trial's going to be held in Boise, Idaho, the same courthouse where Lori Vallow Daybell and Chad Daybell both were tried. And with a new trial judge, they get another crack at it. Now, things can get a little choppy in parts with this episode because we don't have some context that would make things more clear, but I have tried to summarize this the best way I can without it being super confusing. We started the day on Friday with a witness on the stand, and that was Corporal Payne from the Moscow Police Department. He is the lead investigator on this case. He was sworn in on day 1 during the sealed portion of the hearing, so we didn't hear what he had to say before he took the stand on Friday. He said he worked a lot of warrants in this case, and the defense was up first to question him. The first topic they want to talk about is that first AT&T warrant. Now, the witness worked with Special Agent Balance, who is a cast agent with the FBI. This warrant was from December 23rd of 2022, and it was served at 10:03 a.m. The return on that search warrant came in at 3:30 p.m. the same day, and they got that through email. He verified the dates of interest for that search warrant, which were November 12th through the 14th of 2022. Just a reminder, the murder was right in the middle of that on the 13th. They also talk about the AT&T warrant, which was a pin, trap, and trace. A pin register tracks incoming and outgoing calls and texts. It also gives you precision location data. The information from the first search warrant was given to Special Agent Balance with the FBI. He did his work, and they secured that second warrant later in the day at 4:53 p.m. The Apple warrant, the date on that was December 21st, 2022. When the search warrant was executed at the residence of Bryan's parents in Pennsylvania, they found an iPad, but it was in a shared living space. They also found a receipt for an iPad in Bryan's car. They didn't initially seize that iPad because it was in a common area of the house. In his affidavit, he referenced iOS devices can use iCloud for backup. They move on to Bryan Kohberger's arrest. Around 7 p.m. on December 29th, law enforcement arrived in Pennsylvania for Bryan's arrest. The special response team was in charge of apprehending him. The witness observed the final tactical brief before they went in and arrested him. After that, the witness went to another location to wait for Bryan's arrival after he was taken into custody. While they were preparing, they decided to do a knock and announce, which means they knock on the door, announce who they are, and you give the person a reasonable amount of time to answer the door. And the witness said he did not go near Bryan's home. It was in a gated community, so he was not near there when the arrest happened. The SWAT team rode in a Bearcat, which is a Ford F-250 pickup cab chassis, but it has that big box compartment in the back, which is armored. You've probably seen something similar when SWAT is on scene anywhere. The Bobcat was driven up the driveway and parked in front of the house. She has him read from a document, and it's justification for reasoning for amending the original plan for a knock and announce to a hasty knock and announce for quicker entry into the Kohberger home. What are the differences? A knock and announce is where they announce their presence and give the occupants a little bit of time to answer the door. A hasty knock and announce is they announced their presence from the armored vehicle with immediate forced entry. When they were arresting Bryan, the SRT team used a drone to stream that arrest. They were able to watch that on a cell phone, but the witness was driving while the arrest was happening. The witness was also there after Bryan was read his Miranda rights. It was after he was arrested and after he was transported in the police car to the station. One of the detectives did have a recorder in his pocket. I believe they referred to during the transport of Bryan, but the witness doesn't know if any recordings were made inside the house during the arrest. Bryan's car was found in the garage and it was later seized. That's when they found that iPad receipt. The judge asks if the people reviewing the returns of the search warrant had access to the probable cause affidavit, and the witness says yes. The defense gets up and asks, how did they have access? And the witness said people had paper copies and it wasn't a secret. The defense says you couldn't remember specifically who was reviewing the returns from Apple. So how do you know they had access to a search warrant and the affidavit? The witness says that's the beauty of having a collaboration. You share information freely. It's not independent of himself to provide that to other people. They all have it. We're going to talk about Exhibit A here in a second. And if you don't remember from the previous episodes, Exhibit A is law enforcement's statements laying out the facts known to them related to probable cause in order to get that search warrant. The defense says the collective document is Exhibit A. And when you attach that to an affidavit in support of a search warrant, you also add additional language depending on who the warrant is for. There's over 100 search warrant affidavits in this case, and it's your testimony that everyone who had access to the review of the data had access to go in and look at the exact same search warrant affidavit that was executed, and the witness said he believes so. That was it for that witness, and next up was Detective Maui. He is a forensic detective with the Moscow PD. Back to that first AT&T warrant. He doesn't remember specifically what he did, but he was there when it was being discussed. He was the one that served the warrant on AT&T. When he served that warrant, he did not serve it with the affidavit in support of a search warrant attached. The defense asked if it's his practice to serve that, and he said no. They move on to talking about Bryan's cell phone and the data that was gathered from it. Bryan's phone was seized from the search warrant that was executed at his parents' house. The defense asks if a copy of the phone was made prior to the search warrant, and he doesn't know. So she asks if he's aware a copy of the phone was made and put on a USB, and then a second warrant was obtained to look at the contents of that USB, and the witness says yes. She asked the witness if the cell phone was searched prior to getting that search warrant for the USB. He says the extraction was done before the second search warrant was requested, but the USB was not searched prior to the second warrant. He was the one that received the extraction from that cell phone. It was done in Pennsylvania by someone with the FBI, and that agent extracted using a Cellbrite product. Normally, the device is extracted and put on a different storage device just to store it or to share with other forensic investigators. She asks how he got the storage device, and he's not sure. It was still in the FBI packaging when it arrived to him. He doesn't know if the special agent who extracted looked at the contents of the USB before the second warrant was obtained. The defense holds Exhibit A, which was the warrant for the cell phone. She asks if there's any reference to the search warrant affidavit in the warrant and asks, is the date of the crime in the search warrant? And the witness says no. The defense asks, who is the key computer forensics lab? The witness says the key isn't a person, it's a thing. It's actually a key that unlocks the cubicle where that USB was located. The witness was the one that had possession of that key. The defense says, oh, that makes sense because she was confused and thought the key computer forensics lab was the name of a company. She asked who was in charge of searching the USB drive. The witness says the data was reviewed by several different people. She asks who. He doesn't know everybody who did, but he personally looked at some of the information. The FBI also examined it, but he doesn't know specifically who. Moving on to the Amazon warrant. They were served with Special Agent Douglas assisting, and she asked the witness what training he has with Amazon records, and the witness says none specifically. She asks how the Amazon account was located, and the witness doesn't know. He's asked in his affidavit, where is their language of how Amazon holds and identifies what can be collected? If you don't have any training in that, how would you know? The witness said he relied on Special Agent Douglas, who had served warrants on Amazon in the past. They asked if in the warrant, did you say that this was based on your personal knowledge? He said he did because he spoke to Special Agent Douglas about it, and Special Agent Douglas told him, this is what we can request. She asks if he provided a mock-up to help him know how to word it. He doesn't know if he used a mock-up, but Special Agent Douglas would have helped him word it. They move on to the Google search warrants. They obtained 2 different ones. He has no specific training with Google warrants, but he has served search warrants on them in the past. On January 3rd of 2023, the search warrant asked for Bryan Christopher 1994 at gmail.com, as well as 2 phone numbers and an IMEI number. That stands for International Mobile Equipment Identity, and that's a unique 15-digit number that identifies a mobile device. There was a question of what Google could provide, and with one request, Google said there would be too much data. And they helped so that investigators wouldn't have to spend $100,000 plus on data. The defense says, I'm talking about your communication with Google about all the warrants. Were there email and phone calls to Google about getting the warrant? He said he talked to their representative over the phone. The defense asks about there being communication with DeSales about Bryan's college account as well. She asks about communication with DeSales about his college account. She didn't specify whether she was talking about Google or DeSales, but one of them didn't want to produce records pursuant to a search warrant since it was educational records that are protected by federal law. But he wasn't a big part of that conversation. She asked what was DeSales' role. He said he thinks they were just waiting for a warrant, but he doesn't remember. She asks, why did you choose the time frame of January 1st, 2021 through December 30th, 2022? The witness doesn't remember the specific reason why they went back to January 1st of 2021, but he says it was in this time frame that Bryan came to Washington for school. But the defense corrects him and says, you're aware he didn't come to Washington until June of 2022, and the witness says yes. He did review the Google returns, but he's not in charge of evaluating those returns. So it was given to other investigators as well as the FBI. She asks if between warrant 1 and warrant 3, it's gone from 2 gigs to over 13 gigs of material, and the witness said it was substantial. She asks if he verified the materials produced are within the scope of the warrants. He said he verified it was from the specific accounts, but did not go into depth with the evaluation. Moving on to the Apple search warrant. He doesn't remember that one specifically, but he was involved in a lot of the iCloud warrants. She gives the witness an exhibit regarding the Apple warrants, and it's the memorandum in support of the search warrant, and asks if that refreshes his memory regarding what communications were occurring with the Apple warrant. He said it appears there was communication between Apple and the FBI. He was included in that, and there were also calls over the phone. This was more specific to the stalking investigation that the FBI was doing. He was just privy to their conversations. And at this point, the defense had no further questions for that witness. So the state gets up and asks, when you got evidence back from the various providers, did you have access to the affidavit for search warrant and Exhibit A? And did you use that to determine the scope of what you were searching for? The witness says yes. And to your knowledge, did the other investigators helping have access to the affidavit for search warrants and Exhibit A? Yes. After that, the witness was finished and they take a short break. The judge says there's no more witnesses from either party and they'll just move to arguments. The defense says they'll cover several of the warrants. It's not to rehash every argument briefed, but this is big picture comments based on testimony. She says they did question the witnesses about some exhibits and not all, but wants to make clear they're not waiving any of their written arguments. This was just to make some important points. And she starts with that AT&T warrant 1 and 2, which was the trap and trace as well as the USB. The particularity requirement objective is necessary searches should be as limited as possible and particular enough as to what's taken. Nothing is left to the discretion of the officer serving the warrant, and says the government can't seize the haystack to look for a needle. All three of these warrants were issued in late December 2022 into January of 2023. The two AT&T warrants were issued on December 23rd of 2022, within an hour of each other. The first warrant was for November 12th through the 14th, and the warrant itself was extremely broad and it didn't incorporate the affidavit. The defense says the officers admitted they didn't incorporate it. When the warrant says upon offer and proof, that's the same as hereby incorporates an affidavit. She said she pointed out the language in certain search warrant affidavits to show the judge they do know what it meant to actually use the language herein incorporated is Exhibit A. That same language is not used in a single search warrant affidavit. So the incorporation that would be a remedy for this issue potentially of particularity doesn't exist when the search warrant affidavit is not included. Even if you determine there was an English language meaning upon proof and oath, is the same as hereby incorporated. The language in the search warrant affidavits themselves is extremely broad. The affidavit of return services by Detective Payne for the AT&T 1 warrant, it says the warrant was served by email, and he indicated it didn't contain the search warrant in support. The description of the property in search warrant 1 to AT&T described it as just a phone number with no other description of the property, which indicates a lack of knowledge of what was actually seized and going to be searched. The second search warrant, which was the tap and trace, was requested 1 hour after the first return. The data from warrant 1 was analyzed by Detective Balance, and that means Detective Payne was relying on Detective Balance in his affidavit to support it, saying the data had been in their hands for less than an hour, which supported the phone was possibly off going south on Pullman at 2:42 a.m. And there has to be a question of how does this massive amount of data get analyzed in an hour to create a second, more broad search warrant? The pin, trap, and trace warrant is broad, and it goes from June 23rd, 2022 to present. The crime of homicide was stated, but the date of the homicide was not stated. That warrant asked for extensive data, location, timing reports, cell tower information, and the installation of a pin, trap, and trace, among many other things. The cell phone is first seized when Bryan is arrested, is copied by the special agent with the FBI without a warrant, and the USB makes its way to Idaho in an unclear fashion. It seems by Corporal Payne, who was there for the arrest in Pennsylvania. When the warrant is obtained, the USB is put in a safe with just a copy of the warrant, which has no date of the crime, and there's nothing particularized about what's going to be searched. That creates a general warrant with 100% total discretion and nothing to limit the search. She next talks about the Google and the Apple search warrant and mentions that Google contains private emails, schoolwork, and research, among other things. And Apple was a copy of a phone and an iPad that went all the way back to 2016. They were able to identify that the Apple account was first created in 2016. The iPad was purchased 2 years later in 2018. She said there was no effort to do any segregation with regard to Apple or Google. And by January 3rd of 2023, law enforcement knew details they could have used to narrow those notes. They knew Bryan didn't come to Washington until June of 2022. They knew the names of the victims, which was not used in the language of the warrants. They knew the names of fraternities and sororities, and also the students' names who had been at the house the morning of November 13th, 2022. They knew the date of the crime, emails, social media accounts, and names of other people. They knew where the victims worked. They knew their friends' names and phone numbers, but none of that was in there, which made that broad. In Google, it went from 2 to 13 gigabytes between the first and third search warrants. For Apple, she says they're missing some sort of a legal process the state just hasn't filled the gap on, and the witness doesn't fill the gap either. There was a request for preservation on December 21st, 2022, all the way through August, and then there is the production of a warrant. The steps taken in between to get the information to put in the warrants are unclear, and the officers who swore to the contents of the affidavit but now can't remember what that is, she says it's invalidating of those warrants. As far as the arrest, the car, and the apartment, it's not an issue of general warrants. These are more associated with the IGG and the Franks. The defense ends with, I ask you find the warrants I just discussed are general warrants and not particular warrants, and they should be suppressed. So the state gets up for their turn and said, we don't have to go down the rabbit trail the defendant wants you to go down. Regarding the particularity requirements for Apple, AT&T 1 and 2, Bryan's phone, and Google accounts, they weren't general. They were specific to the type of crime, the location, and all but one had limitations. For the one that didn't, the cell phone warrant, that was more particularized in the types of data the officers were allowed to search for. The state said their position is this isn't a general warrant, and the court can see that just by looking at the face of the warrant. They asked to deny that motion to suppress. The defense back up to argue about the raid on Bryan's parents' home, the search on his person in Idaho, and the Amazon warrant. For the most part, they say they'll just rely on the briefing, but they do want to discuss a few things with the judge. The raid at his parents' home. The state had to have a valid warrant to enter the home, and the briefing gets confusing. The warrant to enter the home is what they're arguing in the Franks motion. The defense says the state seems to accept the Idaho Constitution should apply, and it doesn't seem like a big argument is going on there, so the defense will leave that issue alone. The other issue is the right to privacy in the Amazon warrants, and why should the state have to have a warrant for that? The defense thinks the briefing explains it best, but in a case Carpenter and Riley, the Supreme Court starts to do things differently. They recognize the United States has become essentially like a prison where you need fewer guards because you have heavy-duty surveillance systems. In the U.S., we have our phones and internet. All of our activities are easily accessible, and laws made sense in the 60s and 70s, but it stops making sense when you're easily surveilled. Bryan did not have to go out and make purchases. He did it online, and why should that make it private? The reason is the vast amount of information that's now easily accessible to the government. As far as privacy rights regarding the IGG database, they're preserving their argument. It was in the briefing, and they believe Americans have a right to privacy with genetics that they share with other people, and then these genetics are put into these databases. Otherwise, they rely on their briefings. So the state gets back up to talk about the Amazon records. A Supreme Court decision in State versus Miller is the controlling case, and the Idaho courts apply Miller. There's no reason for the court to diverge from that analysis. I looked this up because I wasn't sure what they referenced and they didn't explain it, but in United States versus Miller, the results of that was the Supreme Court held that bank records are not subject to protection under the Fourth Amendment in the Constitution. That case, along with Smith versus Maryland, established the principle of third-party doctrine in relation to privacy rights. The state goes on to say that the Idaho courts apply Miller. The documents are Amazon business records, which detail transaction history. That's akin to bank records. They're not Bryan's private papers, they're Amazon's business records. And Bryan took the risk that this kind of information could be conveyed to third parties, such as the government. Their position is Bryan has no Fourth Amendment privacy interest in Amazon's business records. The next argument by the state, questions raised by the defense regarding the remaining warrants. And they start with the warrants from Pennsylvania. That expands to the Pennsylvania search warrant of Bryan's person and his car, which was located in Pennsylvania. The defense is claiming, as far as the residence of Bryan's parents, they claim there was no valid local warrants, but there were 3 in the state of Pennsylvania. The defense asserts there needs to be a separate special warrant to take him into custody as a fugitive from Idaho. The Pennsylvania police had a valid search warrant for the premises, the defendant's person, and his car. They had lawful process to be where they were when they found the defendant to take him into custody. They talk about the knock and announce issue. The Pennsylvania police were operating in a dynamic sense and reacting to real-time information that was coming in. But as to the defendant's statements, he didn't make much in the way of incriminating statements. He was eventually read his Miranda rights, but there was no interrogation, and Miranda isn't implicated, and there's no issue on the statements themselves. As far as his car and his person, there were valid, specific Pennsylvania search warrants for those, and they're presumed to be lawful. As far as the motion to suppress the arrest warrant, all actions in Pennsylvania were taken with valid search warrants. As far as the search warrant for Bryan's person there in Idaho, there was a valid search warrant for that. Searching his apartment in Washington, there was a search warrant and an amendment to the search warrant, which the applications included all the information, and then the school added their own information. So that was it for the state on that. The defense is back up talking about the knock and announce. The totality of the circumstances on this raid, and they go to mention Dylan Roof, who shot 8 people in the church in Charleston. They mention he was picked up in a parking lot, and the judge interrupts and says he's not familiar with those particular facts, and they're not going to compare it to that. The defense said the state said in their own affidavit they're watching Bryan through snipers as he moved around his own house, and there's no reason to bash the doors in momentarily after yelling their presence. But the judge says it goes to officer safety and also destruction of evidence concerns. The defense says in the cases they've cited where there's evidence of destruction of evidence, they usually give the person the opportunity to surrender. It may not be a long one, but in this case, Bryan was walking room to room with kitchen gloves on. The defendant's motion to compel regarding the state's expert disclosure. This was filed, by the way, on Thursday of last week. The judge said he did not expect the state to have already responded to it. But they're asking the court to remedy their experts' disclosures. The state is relying on Idaho Criminal Rule 16 and the court's order setting out what we should do and what we shouldn't do in this case. The judge says that he doesn't know what their experts are going to testify to. I don't tell a party what you have to disclose about your expert. That's for you to decide. And that's the general framework. So I'm concerned about what appears to be you asking me to tell them what to say in their disclosures. The defense says they've had a couple of disclosures that could have had wiggle words. The judge says wiggle words doesn't mean the expert gets to talk about anything else. The defense said the lists are problematic for them. But the judge says they also have reports that they reference in the lists. The defense says FBI agent Douglas's disclosure, there's a list of financial records, but there's no report telling me what they mean to him. And the judge clarifies, what I understand is you're talking about the Amazon records. The defense says some of that and a lot others. The judge asks if the witness's expertise is extracting and reviewing those records and point out the transactions and dates. He said that's not necessarily expert testimony. Is it expert testimony that on this date he bought a TV? The expert did the work to establish that this is Bryan's account. His credit card was used and delivered to him. The defense says it's, what does this mean? When we get to opinion, it sounds to me like lists don't cut it. And the judge says it's clear you can't say an expert is going to talk about A, B, and C and then go on to give a host of opinions that fall within those topics. They tell their opinions and what they used to get to that opinion. They don't have to give as much detail as the civil rule requirement. They give what they reviewed and they give their opinion. The defense refers the judge to page 9 of the proffer of the state's objection to the defense motion. They say they will continue to supplement their experts' responses based on later discovery or whatever they decide to use. And that whatever they decide to use has me worried. I know the court will use case law when dealing with this. The judge says regarding supplementation, it's allowed. It has to be seasonable based on when the information was received and determined necessary to supplement, but they'll look at that in relation to what may prejudice the other side. The state gets back up and says they've complied through their expert disclosure. And the judge says, let me caution you. Sometimes what an expert thinks they're going to talk about and the lawyer's understanding of that expert, then you submit these disclosures, but make sure you're on the same page if you don't have specific written reports from the expert about what they're going to talk about. Make sure you give a list of opinions they're going to talk about and what that is based on. He tells both sides to over-disclose those opinions because you may find yourself in a bad position if you go into an opinion you think you're going to need to go into because it's not disclosed. He says, I don't want to spend half the day at trial asking, where's that disclosed? And then you're chasing the jury out while you dig through thousands of pages trying to find out where that is. The more exhaustive your disclosure, the less objections and less time will be wasted at trial. He told the state, I don't think your work is done. It's not. The defense wants to make a record about some of the state experts, like the Idaho State Lab. They have their reports and notes, and other than the wiggle room language, the lab reports are fine except one witness. That witness has written no reports, and she could be a rebuttal witness. As far as the cast report, it's really a PowerPoint presentation, and there's not much more analysis. There's just, this will be my testimony without much more. That needs to be cleaned up. We need to know more. Cell phone experts, there's wiggle language the court doesn't know about. Another expert hasn't written a report. Agent Douglas, there's a lot of documents and no analysis or opinion stated. And as mentioned, there's over 60 devices in this case. There's third-party digital data, people listed with lists of devices or social media accounts they're going to talk about. The defense expert told them it would take 3 years to look at all the data. When we get to trial, I don't want to have to worry if this was disclosed. The judge says, for example, if a witness talks about DNA and explains this in sort of a mini class to the jury, the judge expects to see what they're going to say in the disclosure. Disclosing opinions is the most important thing you have to do at this point, talking to the state. The judge ends this by saying he doesn't know if there's going to be a Franks hearing or not. He tells both sides to come up with some dates within the next 3 weeks, just in case it does go to one. I'll keep you guys posted when a decision is made about this Franks hearing. If you're not subscribed to my YouTube channel, don't forget to subscribe there and hit the bell for notifications, because if it's a yes or no, I'll probably just do a YouTube short along with posting on social media. So that way you guys are current with everything, but it's not going to be enough to do a whole episode on if it's just a yay or nay. That's it for today. I hope it was easy to follow along with. Sometimes I get confused and have to go back and listen 3 or 4 times to try to figure out what they're saying, but without context, sometimes it's just not easy. We will see you soon. Hope you guys have a good rest of your Sunday.